Our job is to try and seek absolute clarity, or to get to as close as clarity as we possibly can, so that our audience can understand what is going on. So basically, the appeals court has not changed anything or said anything contrary to the provisions of the Constitution with regard to the defection of the lawmakers. All it dealt with was the issue of the jurisdiction, and by extension, the issue of possible judicial overreach.
You said it very, very correctly, I will say, Charles. The substantive issue has yet to be determined, even at the High Court by the Honorable Justice Wali. It was even the ex parte application that prompted the making of that interim order. It was the interim order that is the subject matter of appeal. The lower court has not even gone into the substantive issues. But I would say that also the Court of Appeal could not delve into those issues because it is yet to emanate as an appeal to the Court of Appeal. The Court of Appeal only exercises appellate jurisdiction. I cannot go into determining substantive issues. It was purely an appeal on the basis of an interim order made by a court, on whether the court has the jurisdiction, the competence to determine that case. So the substantive issue is yet to be touched. But if you look at that order, you look at it and you think that maybe after that order, is there anything in the substantive action that needs to be determined by court? Because I'm very, very sure that if you look at the prayers or the reliefs in the pleadings before the lower court, it must be the same thing as what the court had ordered. And that is why we are saying that circumspection on the part of the judiciary is very, very important. And while that is going on, I also believe that the parties cannot give their own interpretation to judicial decisions. They are there. And everybody understands that, well, this decision of the Court of Appeal today has not given anybody anything. It has just defined the limits of the exercise of jurisdiction of the High Court of Rivers State with regards to the vacancy of the membership of the House of Assembly. And we are also saying that, well, the National Assembly also has the powers to determine that vacancy by virtue of the Constitution. Whether it panders with the constitutional and the federal framework or not is a different matter altogether. These are constitutional matters. It's for the courts, particularly the Supreme Court, to give an interpretation that will satisfy all and sundry and maybe help us to develop our case law and jurisprudence. But by and by, there's nothing that is gained from that decision. There's nothing that is lost. The only alternative available for the parties is that to go and initiate a fresh action at the Federal High Court or go appeal the decision in the Supreme Court, where we can have better understanding of what the Court of Appeal is saying. But to the very best of my knowledge, the people jubilating, I don't know what they are holding on to, and I don't see what is there that gives them any cause of joy or anything. What is important is that the court later went, though it is in a concurring decision of the court to say the status quo be maintained. What amounts to the status quo is what we may not rightly here state. But then, that's what I consider to be an obiter dictum of the court, because having stated that the lower court has no jurisdiction, there's no other material, there's no other subject before the court for it to make that order for maintenance of status quo.
Well,